Should you consider working after filing for Social Security disability? I'm Jonathan Ginsberg. I'm a Social Security disability attorney representing claimants nationally. And I get this question a lot from folks who have applied for disability and who think they want to try to go back to work either because they need the money or because they're bored or simply because they're not sure that the disability case is going to come up anytime soon. Of course, the delays can reach 18 months, 2 years. So for whatever reason, they want to try to go back to work. So is that a good idea? And I will tell you at the outset, my general sense is that Social Security disability judges see claims in black and white terms. Either you're disabled or you're not. Unlike the VA, where you might have an 80% disability rating or a 50% disability rating, Social Security disability basically says you are either disabled or you're not. So if you're working, that's going to put some question in the judge's mind whether you have the capacity for work. But there are pros and cons both ways. I want to go through those with you. So the pros of trying to work after applying, and again, this is a situation where you've applied for benefits and you have an opportunity to go back to work, either full or part-time. The pros would be obviously you can earn some money. And as noted, the disability process can take a long time, and having no money coming in for 2 years or so can be burdensome. So if you try to go back to work and you can earn some money, that's a good thing. And of course, if you're able to go back to work, then you can cancel your disability application. There's no penalty for doing that. So certainly it's a way to test your capacity for work, maybe at a job that's a little bit easier than what you had done before. I think secondly, if you try to go back to work, that can enhance your credibility with the judge, meaning that if you go in front of a judge and you say, Your Honor, I left my long-time job, I'd been there for 15 years as a teacher or as a nurse or whatever, a postal worker. I thought I would try to go back to doing something a little bit easier. Here's what I tried to do, but I was not successful. So an unsuccessful work attempt, and that's generally defined as something when you're working at full-time for between 3 and 6 months, that can be evidence that you have the right motivation and you're trying to go back to work. So that can certainly enhance your credibility if you have unsuccessful work attempts. And I think third is if you try to go back to work and you're not successful, you can ask co-workers or supervisors to give you written statements that describe the struggles you were having, the difficulty you were having with attendance, or the need to take excessive unscheduled breaks. So all those things can benefit your case. On the downside, I think if you go back to work, again, you're going to signal to the judge you have some capacity for work, and realize that judges are seeing, let's say 5 or 6 cases in a particular day. They're holding hearings, and 5 of those cases, the person, the claimant, the other claimants have not worked at all. You come in and you've worked. So it's going to right away put you in contrast with those other folks. Some judges are going to see it as a enhancement of your credibility. Other judges are going to say this is evidence that you do have the capacity for work. So I think if you do go back to work, it's really important to keep very accurate records. And what I mean by that is that if you go back to work and you're doing it part-time and you work for 3 hours a day, but you have to do it every other day because you're so exhausted or physically tired or in pain after 3 hours of part-time work, you've got to take a break and then go back and do it the next 2 days later. That's very different than working 2 8-hour days in a row. Because if you work 2 8-hour days in a row, the judge may conclude, well, you would have worked more, but there just wasn't the work available. Whereas if you're saying I can only work 3 hours a day every other day, that goes to your capacity. So realize that, as well, that Social Security has a concept called substantial gainful activity, and that basically is that if you earn a certain amount of money, it's presumed you're able to work. So you want to keep that in mind too. For 2020, the limit is $1,260 of gross income in a month. For 2021, it's $1,310. So if you earn more than that, that is suggesting that you have the capacity for work. So if a judge sees earnings at or above SGA level on a continuous basis, then at a minimum the judge is going to look to possibly change your onset date, or the judge might conclude that you in fact have the capacity for work. So working after applying for benefits is not always a bad thing, but just keep in mind that the default position I always take is that it should be kind of a thing where you realize that you are putting a little bit more risk into your case. Again, I would never tell somebody not to work if they think they can. Just be aware of what the consequences are, and certainly keep very, very accurate records about it, so that if you're questioned about what you did, or if the judge wants to know more, you can explain that you did this work. The most you could do was very limited part-time work, and that you are trying to work. You don't want to be disabled, and you can use it, make it into something in your favor. Please visit me online, ssdanswers.com. I have a free Secrets to Winning Disability Survival Kit there. A lot of great information delivered by email. You can also ask me for a case, a no obligation case evaluation. Happy to give you my thoughts about your particular situation if you're not already represented. And finally, if you have not done so already, please subscribe to my channel on YouTube, like this video, like our Facebook page, and subscribe to that as well. This is Jonathan Ginsberg, wishing you the best. Thanks a lot. Hi, this is Jonathan Ginsberg, and I hope you found this video helpful. If you'd like to know more about how to win your Social Security disability case, I'd like to invite you to download my Secrets to Getting Approved Early Survival Kit that I created just for people like you. Currently, I'm making the Survival Kit available at no cost, and I encourage you to grab your copy now. Some of the topics I cover include: how do I know if I have a case? Is it the right time for me to file my claim? 9 common mistakes that can doom your case. The 3 must-have arguments you use to win your case. And a topic that every disability claimant wants to know: how to avoid trick questions from the judge. If you or a loved one need to win Social Security disability benefits, you'll find the Survival Kit essential reading. Download your Survival Kit right now and at no cost. Just visit ssdanswers.com/survival and sign up. It's that easy. Please act now. And as always, I wish you the best.